right. Well, good afternoon. The 34th District Court is now in session. First cause for the afternoon is cause number, I believe, 2018-0D06098, being the state of Texas versus Charlie Duke Campbell. I believe he is present. His attorney, I believe Mr. Avalar, representing the firm of Wyatt and Underwood, is present. And I believe Ms. Ritchie is present representing the state of Texas. We have a special court reporter in here today, Ms. North. We also have the district clerk present. I believe everyone is present. Is everyone ready to go?
The defense is ready, Your Honor. Yes, sir.
All right. Okay. Is your true and correct name Charlie Duke Campbell?
Yes, sir.
And is your date of birth 4/9/1982?
Yes, sir.
And do you recognize your attorney there, Mr. Avalar?
Yes, sir.
Okay. And Mr. Avalar, do you recognize your client, Mr. Campbell?
I do, Your Honor.
All right. I believe then we're ready to proceed. If the state would please state the plea agreement.
Yes, Your Honor, this is 10 years deferred, a $1,000 fine, 200 hours of community service, urine and breath testing, curfew, drug classes, drug counseling, and all other standard terms and conditions.
All right. And is that your understanding of the plea agreement?
Yes, sir.
Mr. Avalar?
Yes, sir, it is.
And is it also your understanding of the plea agreement, Mr. Campbell?
Yes, sir.
Okay, now you understand that the plea agreement is not absolutely binding upon me, but should I choose not to follow it, should I choose to be harsher than that, you could withdraw your plea and we could proceed to a trial on this matter at a later date. But if I follow the plea agreement, it is final. You cannot withdraw your plea. You cannot appeal this case without my consent. You would begin serving that probation immediately. You understand that?
Yes, Your Honor.
Now, we have in front of us some documents this afternoon, marked States Exhibits 1. The guilty plea and waiver forms in this case, they bear the signature of your attorney, the state's attorney, and what appears to be your signature. Did you in fact sign these documents?
Yes, Your Honor.
Did you read them before you signed them?
Yes, Your Honor.
Did you understand what you were reading and signing?
Yes, sir, Your Honor.
Did your attorney further explain to you the meaning of these documents?
Yes, Your Honor.
Did you understand what he was telling you?
Yes, Your Honor.
Do you have any question about the meaning of the documents?
No, sir, Your Honor.
So that there's never any question, let me briefly explain to you what they mean. Primarily two things. First, you're coming into court telling me through a judicial confession, yes, Judge, I did commit this offense. And secondly, you're telling me you understand that you're giving up some valuable rights here today. The most important of those rights is the right to a trial by jury, not only upon the issue of guilt, not guilt, but also upon the issue of any potential punishment. You fully understand that?
Yes, Your Honor.
All right. Now, understanding that, then how do you plead to this indictment, guilty or not guilty?
Guilty, Your Honor.
Are you entering your plea of guilty freely and voluntarily?
Yes, sir, Your Honor.
Did anybody force you, threaten you, coerce you, or in any way make you plead guilty?
No, sir, Your Honor.
Did anybody promise you anything or persuade you in such a manner you felt you had to plead guilty other than the plea agreement stated on the record in open court here this afternoon?
No, sir, Your Honor.
Now you understand, I believe this is, well, let's see, what degree of felony are we looking at here? Because there are several counts, right?
Yes, Judge, it is a third and a first.
A what?
A third degree and a first degree, Judge?
A third degree and a first degree?
Yes, sir.
Is the evading, and the first degree is the manufacture delivery of the narcotics?
Yes, sir.
Okay, and in neither indictment are you proceeding under any enhanced paragraphs?
Correct, Judge.
All right. So you understand the potential punishment for a third degree felony is not less than 2 years, nor more than 10 years in prison, a fine not to exceed $10,000. But on a first degree felony, the punishment is not less than 5 years, nor more than 99 years, or up to life imprisonment in the state penitentiary. But in both cases, I could place you on probation instead of putting you in prison On the third degree, for not less than 2 nor more than 10 years. On the first degree, not less than 5 nor more than 10 years of probation. You understand that?
Yes, sir, Your Honor.
Okay. Now, you are a U.S. citizen.
Yes, sir, Your Honor.
And how old are you, sir?
39, Your Honor.
39, did you say?
Yes, sir.
And how far did you go in school?
I got my GED, sir, and I got some college courses.
Okay. And you are certainly able to read and write the English language.
Yes, sir, Your Honor.
Have you ever been under the care of a psychiatrist or psychologist for mental illness, mental disease?
No, sir, Your Honor.
Okay. Ever suffer any serious head injury?
No, sir, Your Honor.
And are you telling me you are mentally competent to enter this plea?
Yes, sir, Your Honor.
Okay. And Mr. Avalar, you and your firm have had time to go over the facts and circumstances of the case, legal aspects of the case, and had time to evaluate your client's mental status?
Yes, Your Honor.
Based on all that, are you representing to me that you believe he is mentally competent to enter this plea?
Yes, I am, Your Honor.
Then based on your representation, Mr. Avalar, your representations, Mr. Campbell, the court's observations of you in court, both here today and on prior occasions, I find that you're competent to enter the plea. The state may summarize the evidence.
Yes, Your Honor. Had the state proceeded to trial on this case, we would have proven each and every element listed in the indictments for both counts beyond a reasonable doubt.
Okay. And any objection to the evidence?
No objection, Your Honor.
Received. Now, the court has gone over with your attorneys and the state's attorneys all of the factual information in the case and your prior criminal history. And I find the evidence is sufficient to find the defendant guilty. But however, I am not finding you guilty because this is a deferred plea. And I'm sure your attorney explained to you what deferred probation could mean, correct?
Yes, sir, Your Honor.
But I'm going to go over it with you again. Deferred probation means this. I am not, while I'm not finding you guilty today, I am going to wait until some later date to finally adjudicate or decide your case. That will be based on your conduct. If you successfully complete the probation, you do everything you're supposed to do. At the termination of the 10 years or at any time less than that, if I should choose to let you go early, then the case against you is dismissed with no finding of guilt. That could be a benefit to you in the future in job prospects and things of that nature. That's the good way for deferred probation to end. However, if you're on straight probation, if on the deferred probation, if you don't do what you're supposed to do, then the court, particularly if the two things that get defendants in most trouble on probation, the most serious trouble, is committing another offense or to stop reporting, to abscond. Okay, you understand that?
Yes, sir.
Those two things generally get you revoked and get you sent to prison. Now, the other conditions are also important, and I may, those could also result in conviction or, incarceration. But the two most important ones are the ones I mentioned to you. Now, the difference between deferred and straight probation is if you're on straight probation, the worst thing I can do to you is sentence you like if you were on straight probation on these cases would be 10 years in prison because that's the maximum. But, and it's still the same thing on the third degree felony, but on the first degree felony, I'm not limited to the 10 years probation. If you're on probation on a first degree felony deferred, and I find that you have violated your probation, I can then, if I find the evidence is sufficient to find that the allegations are true, then I can revoke that probation, find you guilty, revoke it, and I can sentence you all the way up to life imprisonment. You understand that?
Yes, sir, Your Honor.
Okay. Now, understanding that, you still want me to grant your motion for deferred adjudication in this case?
Yes, sir, Your Honor.
All right. Now let's go over a couple of things because I want to make sure that everything is, you have an understanding about what's going on. Let's see here. I don't have a lot of background information on you. Are you married? Do you have children? Were you employed?
I have children, sir, and I have a job, and I'm also enrolled in a reentry program. So on release, I'm going to be in a reentry program where it's a 60 to 90 days where we have drug classes, and they have the state pays for the hotel, and I'm going to be living there, and I can't have nobody over or not get kicked out. So I'm enrolled in a reentry program where it helps me find a job and everything, sir.
Well, that's very good, because I think that's been the major problem in your life has been some, drug addiction issues. It's cost you a lot of freedom over the years. And in fact, like I was telling you, if you commit other offenses, you could spend a very long time in prison.
Yes, sir.
And I don't think you want to do that.
No, sir, I don't. No, sir.
I sense that you want to make a restart of your life.
Yes, sir, I do. And I thank you and I appreciate you, sir.
Well, the state and the defense have looked at the case, and I think that hopefully I've heard things that you're ready for a major change.
Yes,
And-
sir.
And I really hope that is true. When you get out, or where are you're going to live at what facility?
It's a reentry program. They say the state of Texas or the city, the county, they rented a hotel on the west side. It's peer people that are part of the reentry program, and they take UAs daily, and you can't have nobody over or you get kicked out. So it's a reentry program. I don't know exactly the hotel they stay in, but I have all the information in my cell that they gave me, and that's where I'll be going on release.
Good. Now, do you still have, I think you have family here in El Paso, don't you?
Yes, sir, I do.
Who's here in El Paso that's family?
My mom and my brother and my sister.
Well, I am sure that your mother has not given up on you, because that's the way moms are. Okay. And it's probably caused her a lot of stress over the years to watch some of this for you. And I don't think you want to cause her any more harm and stress. It's tough. And I think, I want you to feel good about yourself, but I'd really love to see your mom be proud of where you've come from this day forward. I think that could mean a lot to her, and it could mean a lot to you. And like I said, get back on track, get a good job, get back on your feet, and hopefully you can break this terrible addiction and become a good, productive citizen after this. So I am going to follow the recommendation. It's 10 years deferred, and good luck to you, Mr. Campbell.
Thank you, sir. Appreciate you, sir.
Okay, and those two sentences will run concurrent.
Yes, sir.
All right, very good. Thank you.
Thank you, Judge. Appreciate it.
Thank you.
And Your Honor, may I be excused?
I don't think you had any other cases.
I don't believe I do, Your Honor.
Okay, let's move to Mr. Castillo. And I believe that's going to be Ms. Pages is on that case.
Yes, Judge, it's my case.
All right.
Yes, ma'am. Like 22 years ago.
All right. I believe this is cause number 2021-0D00390. The state of Texas versus, is it Demetrio Eder Castillo?
Yes, sir.
That's your
Yes,
true
Judge.
correct name? Okay. And is your date of birth 1/28 of 1989?
Yes, Judge.
And you recognize your attorney there, Ms. Pages?
Yes, Judge.
And Ms. Pages, do you recognize your client, Mr. Castillo?
Yes, Your Honor.
Now, I understand there's a plea agreement in this case. Would you like to state this on the record, Ms. Ritchie?
Yes, Your Honor, the plea agreement is 5 years TDCJ. And we will be declining the resisting arrest, search or transportation misdemeanor. And that is 2021 P file 01449.
All right. Now, I think this case had some complainants in it. Did you all in your office confer with the complainants in the case?
Yes, we did, Judge.
And they were made aware of this resolution?
Yes, they were, Judge.
And did they seem to be in agreement with it?
Yes, Your Honor.
All right, that's very good. All right, now, let's see about where we have we have in front of us some documents marked State's Exhibit number 1, the guilty plea and waiver forms in this case. They are on both counts 1 and counts 2. They bear the signature of your attorney, the state's attorney, and what appears to be your signature. Did you in fact sign these documents?
Yes, Your Honor.
Did you read them before you signed them?
Yes, Your Honor.
Did you understand what you were reading and signing?
Yes, Your Honor.
Did your attorney further explain to you the meaning of these documents?
Yes, she was very helpful, Your Honor.
All right, well, she's a very good attorney.
Yes, sir.
Well, now, in that regard, you understand what
Judge, you're
she
breaking.
was
now.
telling you?
You're coming in.
Your Honor, I can't hear you, Your Honor. You're breaking up.
And did you, can you hear?
You're freezing up.
Yeah, it's Coke speaking in
Freeze or something?
yeah, it's kind of freezing a little bit. Let's
Oh,
try it again.
okay. Okay, could you hear me there? Let me start that part over again. That part was that, did you understand everything your attorney was telling you?
Yes, Your Honor.
Okay, and additionally then, do you have any questions about the meaning of these documents?
No, Your Honor.
All right, so that there's never any question, let me briefly explain to you what they mean. Primarily two things. First, you're coming into court telling me through a judicial confession, yes, Judge, I did commit these offenses. And secondly, you're telling me you understand that you're giving up some valuable rights here today. The most important of those rights being the right to a trial. You understand that?
Yes, Your Honor. I understand, Your Honor.
Okay. Understanding that, then how do you plead to this, these charges? And of course, it's not just on the issue of guilt, not guilt, but it's also upon the issue of any potential punishment that you're giving up the right to trial by jury. You understand?
Yes, I understand, Your Honor. And yes, I'm guilty, Your Honor.
Okay. Now, so you are pleading guilty? Are you?
Yes, I'm pleading guilty, Your Honor.
Okay. And are you, has anybody forced you, coerced you, or in any way made you plead guilty?
No, Your Honor.
Has
No.
anybody promised you anything or persuaded you in such a manner you felt you had to plead guilty other than the plea agreement stated on the record in open court here this afternoon?
No, Your Honor. It was my decision.
Now, you understand the potential punishment on these. The first degree felony is 5 to 99 or life imprisonment. The evading is a third degree, I believe. And is that correct? Is it pled as a third? It's not enhanced or anything?
Yeah, yes, Your Honor.
Correct, Your Honor.
Okay, so the potential punishment for that one is not less than 2 years nor more than 10 years in prison. So you understand I've got to sentence you somewhere within those general guidelines.
Yes, Your Honor.
You are a U.S. citizen?
Yes, Your Honor.
And how old are you?
I'm 32, Your Honor.
How far did you go in school?
I just finished high school.
You can read and write the English language though, correct?
Yes, Your Honor.
Have you ever been under the care of a psychiatrist or psychologist for mental health or mental illness issues?
Yes, I have, Your Honor.
What kind of issues have you had? What's the diagnosis?
I'm paranoid schizophrenic, Your Honor.
Okay. And have you had Are you presently under medication?
Yes, Your Honor. Started my medications a week after I got here.
Those
On
are
my
those medications.
incarceration. Yes, starting off my incarceration, Your Honor.
Are the medications helping you?
Yes, Your Honor, they actually are helping me.
Are they helping you to such a degree that you understand everything that's going on here today?
Yes, Your Honor. I understand exactly what's going on.
All right. So, counsel, and you believe you are mentally competent to enter these pleas?
Yes, Your Honor. I believe I'm competent.
And Ms. Pages, you've gone over the facts and circumstances of this case with its multi-counts, and you've gone over the legal aspects of the case, and also have you had time to evaluate your client's mental status?
That is correct, Your Honor.
And are you representing to me also that you believe he is mentally competent to enter these pleas?
Yes, Your Honor, he is.
Well, then based on your representation, Ms. Pages, your representations, Mr. Castillo, and the court's observations of you in court, both here today and prior occasions, I find that you are competent to enter these pleas. The state may summarize the evidence.
Yes, Your Honor, had the state proceeded in a trial on this case, it would have proven each and every element beyond a reasonable doubt in both of the counts.
No objection, Your Honor.
All right, received. Based on the evidence before the court finds the evidence sufficient to find the defendant guilty. We've also had extensive pretrial conferences on the case, bond hearings on the case, where we've gone over the facts and circumstances of the case. We've gone over the defendant's criminal history, his past mental health issues. And based on all that, so like I said, I find that the evidence is sufficient to find him guilty. I do find him guilty. I'm ready to proceed upon the issue of punishment. It seems that when these incidents occurred, you may not have been taking your medications, it looks like. Is that correct?
Yes, Your Honor, I was not taking my medication.
Okay, and you see that taking the medications now help you a lot in focusing and not getting in trouble.
Yes, Your Honor, I'm trying to change my life, but I need to have the consequences first, I guess, Your Honor. I know I messed up, and I just want to say I'm sorry to even the person that I harmed in the case or whatever. I want to say sorry for my actions, and hopefully I been able to change my life.
And I think that they have been somewhat forgiving too, because they didn't demand like more time or something in this case, and so it's good that you've seen the error of what occurred, and it's good that they're trying to move forward too. So hopefully all of you can move forward from this. The biggest lesson you learn is, stay on those medications. Have you ever heard of diabetes?
Yes, sir.
Okay. Sometimes these mental illness issues are much like that. You've got to keep taking the medication or you'll get sick again. You'll have problems again. Even though sometimes you start feeling better, it doesn't do, you can't stop taking them. You understand?
Yes, Your Honor, I understand.
And then also it's very important not to mix those medications with other things, other types of drugs. Anytime you mix it with other things, it can cause you a lot of mental health issues and could cause you to get in trouble again, which you don't want to get in trouble again, I'm sure.
Your Honor, I don't.
Okay. Well, I'm going to follow the recommendation. It's going to be 5 years to serve. I'm going to give you credit for all the time that you have served in this case. And good luck to you, sir.
Yes, thank you.
And Your Honor, aside from,
Yeah, the counts run concurrent. What?
yes, thank you, Judge.
Yeah, the counts will run concurrently.
Yes, sir.
All right.
Thank you, Your Honor. God bless you.
Thank you. Well, same to you and same. And it's in the case too. All right. Here we go. So now the next case I'm going to hear is with regard. I don't know why it's coming in. My internet connection is unstable. Am I gonna have to move somewhere else?
You might have to, Judge, because you're freezing up.
Okay, I mean, at times I break up. I mean, I'll see it flash on the computer somewhere. I mean, but I always sit in the same place here. And
Huh.
it usually isn't any trouble, but I don't know why it's trouble this afternoon. Well, if I have to move, I will move. Let's see. Who is hearing the case with Mr. Gomez? Is there a defense attorney on this one? I thought,
Yes, Judge, it's me. Sorry about that.
yeah, I thought it was you. Because I think, didn't we talk about this case a little earlier this week?
Yes, Judge, and he was going to be screened for BHRTC, and I believe Miss Ortiz needed him to be brought over for that purpose.
All right. So let me go over this. Mr. Gomez?
Yes, yes, Your Honor.
Okay. Your attorney and the state's attorney and myself have discussed your case earlier this week, along with the probation department.
Yes, Your Honor.
And we have come to the conclusion that you have, and I think we came to the same conclusion that you did, because we worked on your case before. And I think that if I'm not mistaken, I thought that maybe inpatient treatment was going to be necessary because, you know, methamphetamine is such a difficult drug to break away from. And I think you've come to the same conclusion that you need some serious help to break this addiction. It is not an easy one. I've been talking to some people, and I'm not sure anyone has been able to break away from a methamphetamine addiction without professional intervention. So it's good that you've recognized that. I think is that correct?
Mr. Moody, that wasn't my major problem. My major problem was drinking alcohol. And one of those nights I was drugged up, yes, I admit to that. But no, that's not my major problem, Your Honor. But I do admit that I made a mistake.
Have
Yes,
you have your major problem is alcohol?
yes, Your Honor.
Okay.
And I would like to get on.
All right. Well, that is also not an easy one to.
Yes, Your Honor.
A lot of people have struggled with alcohol addiction too.
Yes, Your Honor.
Well, and they have I guess both the state, the defense, probation department, and myself are convinced that instead of trying to revoke your probation and send you to prison, they want to give you a chance to for you to grasp the opportunity to make these changes.
Yes, Your Honor.
Treatment. So we're going to give you a chance here at treatment. I don't know, have you ever had inpatient treatment before?
No, Your Honor.
Okay, well, sometimes it's necessary, and so I'm going to modify your terms and conditions of probation. I'm not going to send you to prison.
Yes, Your Honor. Thank you.
We're going to give you another chance.
Yes, Mr. Moody. Thank you. Your
One that
Honor.
has to make the most of this opportunity.
Yes, Your Honor. Thank you so much.
You'll be the person that you and you alone make the
Yes.
decision whether you're going to succeed on this treatment or whether it ultimately will end up in revocation. You know, I'd rather it not end up there. That's why we want to see you get another chance.
Yes, Your Honor. Thank you so much.
Okay, well, I'm going to modify your terms and conditions to the VHRTC. And that facility also, you know, some of it, how long you spend there depends on how hard you work at it.
Yes, Your Honor.
Sometimes it's 3 months, sometimes it's 6 months, but it a lot of times has to do with your effort. The more you put into it, generally the quicker you get out.
Yes, Your Honor.
You know, the more you focus on it. And I know there's a lot of things to focus on when you're there. You know, you could focus on negative things, but if you keep your head down and focus on the critical things, getting better
Yes, Your Honor.
yourself, you know, and making sure you listen to what they're saying, because they're going to try to give you the tools now
Yes, sir.
that you don't relapse. All right.
Yes.
Or if you start to have a relapse, you get help before it gets too bad.
Yes, sir.
We don't like to see you spiral all the way to the bottom
Yes, sir.
because it takes a lot of more effort to get out.
Mhm.
All right. So
Yes.
I will modify your terms and conditions of probation to BHRTC.
Yes, sir.
Hopefully they will have a bed available for you over there within the next 30 to 45 days.
Yes,
Okay.
sir.
So I'm hoping that, I don't necessarily know how long it takes. And I can't promise you, but, obviously if something hasn't happened, within about 45 to 60 days, Ms. Page, just let me know. Okay?
Yes, yes, Judge, thank you.
Okay. Thank you.
Thank you.
All right. Very good. Did you have any questions?
No, Your Honor.
All right. Well, good luck and on your rehabilitation efforts.
Thank
And
you, Your Honor.
I think finally you've maybe gotten to the point that, you've recognized that you've got to make something more out of your life than where you've been.
Yes, Your Honor. Thank you so much.
And that's good. Do you have a wife and children out there?
I have a wife. My child is older. She lives in New Jersey. She's grown. I have a grandson. And
But I'm sure your wife is anxious for you to get out. I'd like to
yes, Your Honor.
restart that, relationship. What about a job? Have you got good job prospects?
I'm disabled. I get disability,
Oh, okay.
SSI.
All right. Well, good luck to you, Mr. Gomez, and
Thank you, Mr. Judge Woody.
thank you. Take care. Now let's have Mr. Is it Martinez?
Yes, sir.
All right. Mr. Martinez, is that Dylan or Dylan?
Dylan.
Dylan Martinez. Okay, Mr. Martinez, you're also on probation.
Yes, sir.
You probably were listening, or may have been listening when I was talking to Gomez there. And your attorney here is, let's see, is that Mr. Moore?
Yes, sir.
Okay. And, you've been on probation for a while out of this court. You've had some problems,
Yes, sir.
Your attorney has worked hard to try to convince the state and myself that we should give you one last opportunity at some rehabilitation. I think at one point, I kind of suggested some inpatient treatment, but I know that you've got, I know you've got children out there. I know you've been working, but again, breaking the addiction issue is never easy. But apparently we're going to go ahead and give you also the opportunity. We're going to modify your probation to the BHRTC so that you can get some treatment. Or do you think you're ready for it?
Yes, sir. I need it.
Okay. Well, that's it. If you're the only person that can tell us that you're ready, if we can offer you the best treatment in the world, but if you're not ready, it doesn't do any good.
I'm more than ready.
All right. Well, I think it is time. I think this time you can make it. Apply yourself, work hard at it, work hard at the program. They've got a lot of good people out there that can give you a lot of tools to help you break this cycle of addiction. And when you do, then you can get back to being the kind of guy you really want to be. What are your hopes and dreams? What do you want to do with the rest of your life?
Just be a solid citizen.
Okay. And when you get out, have you got a job or anything lined up?
I'm gonna go work with my father-in-law.
Good.
I'm gonna be sterilizing medical equipment.
All right. And where are you going to live when you get out?
I'm gonna go back to my mom's hopefully.
Okay. You're going to stay with your mom?
Yes, sir, but she wants me to complete the rehab first.
Yes. Well, when you get out, I want you to make your mom proud,
That's all I want.
and she'll always love you. That's not a question. But the problem will be, I think there's probably been some disappointments, not just you, but
More than one.
every day is a new day, and you're getting a new start.
Thank you.
And hopefully you'll make the most of this opportunity, and we'll never see you again except to get off of probation someday. All right. All right. Well, I will modify your probation to the BHRTC. And again, Mr. Moore, if for some reason, it's going to take between 30 and probably 45 days for them to get you transferred over there. So I want to make sure that gets done. If that doesn't get done within about 60 days, Mr. Moore, okay? Because I don't like people to sit there waiting too long, because when they really want treatment, I want to get them treatment. And of course, that's the problem is that there's a lot of people that unfortunately need treatment. And so there is a backlog of people getting over from the jail to the BHRTC. All right. So be patient, keep the good attitude that you have today, and, keep working hard at it. And I'm sure that this time you will succeed.
Thank you, sir.
All right. Thank you.
Very good day.
Okay. And now it would be Mr. Lasso.
Thank you, Judge. May I be excused?
Yes, you may, Mr. Moore. Thank you.
Good afternoon, Judge.
Good afternoon, Mr. Dunham.
Afternoon, Judge. This is Alex.
Right, Mr. Cuellar, okay. And this is a straight up bond reduction hearing, correct?
Yes, sir.
All right. Let's go over, first of all, let's see, I've got two charges here: smuggling of persons and possession of controlled substance between 4 and 200 grams. And what is the bond presently set at?
35,000, Judge.
That's the total combined bond?
That is my understanding, yes, sir.
Okay. And I believe that he has been in jail for about 152 to 153 days.
Yes, sir, 153 days.
And which indicates that he probably cannot make that bond.
No,
Right.
sir. No, sir. And I recently took this case on, but I have been in contact with family. He does have family here. It's just they can't come up with the bond for him under the condition the bond companies are asking for. He was born and raised in El Paso.
Is there any amount of bond that he could make, or is he asking for just a straight PR?
Well, we're asking for a PR bond, Your Honor. We would expect it to be under enhanced supervision conditions. A little bit about Mr. Lazo is that he is born and raised here. He was living outside of El Paso up until last year. His mother passed away from cancer. He came back here for the funeral, of course, and then also his father, who is 88 years old, Crescencio Lazo. He has a pacemaker, so Mr. Lazo will and had been living with his father, Mr. Crescencio Lazo, to be his caretaker, essentially.
His father is how old? What?
88.
88?
88 years old with a pacemaker. Mr. Lasso also was working as a mechanic. He's trained as a mechanic and a welder. He lost his job last year because of COVID. However, I'm confident with his training and the current economic situation, people need people to come back to work. He can find a job pretty easily with his qualifications. He does have a GED. He does have family in El Paso. I've been in contact with his sister frequently. And just something else to point out, we are set for trial. I don't know if that's going to go to trial, but if it were, we're looking at another 8 months. And the other issue is that, and this isn't the district attorney's office in El Paso's problem. My understanding is labs have been held up by the state lab. We don't have lab reports yet. It's been, I guess, 5 months now. So even if we were to negotiate a plea agreement acceptable to my client, it would be difficult to accept that without having lab reports. So we're kind of at an impasse at the moment, and that's not district attorney's office here. That's not their fault. I understand the labs are backed up. However, given all these circumstances, the length of time he's been in, the length of time until our trial, and the length of time we've been waiting for labs, we are requesting a PR bond. And the alternative, at least lower the bond to an amount the court's comfortable with, but that my client could reasonably be expected to make.
Okay. From what I understand, Mr. Cuellar, let's see, I think at the judge's pretrial conference, we did go over some of the facts and circumstances of the case. And I think I just heard earlier this morning when we were doing another case that DPS is now using the New Mexico State labs to try to speed up the lab process, and hopefully we'll have some lab results fairly quickly on some of this backlog.
Yes, Judge. I know the DPS had, I think, gotten funding to do approximately 600 cases. That's a pretty big number. I wish it were all of them, but unfortunately it's not. So we are noticing that more labs are coming in quicker. I think with the pandemic happening, some of the labs were actually done. They just never got turned over, or the results never got turned over. So it may just be simply an issue of asking for the results to be uploaded. So those should be coming in fairly quickly. And then the drugs on this case, Judge, it was cocaine and rock cocaine, and then oxycodone. So those aren't two of the drugs that are typically held up. I know marijuana has become a hot button issue, so that's not an issue here. So hopefully those drugs are tested pretty quickly. But in terms of the state agreeing to a lesser bond or a PR bond, the state's apprehension at this time, Judge, is that Mr. Lazo does have a history, at least dating back all the way to 1995 here in El Paso, unlawful carrying of a weapons conviction, and then 2 separate assaults. Those were in 97 and 98, both convictions. Then he picked up a PG-1, less than 1 gram state jail. That was a conviction, I believe, where he got misdemeanor time. And then he left to Louisiana. And when he went to Louisiana, he was convicted on December the 30th of 2011 for felony carnal knowledge of a juvenile 14 years of age or older. So it was basically sexual assault of a child. He is on lifetime sex offender registration. Then he comes back to El Paso. And when he comes back to El Paso, that's when he makes this, that's when he picks up the alleged case here with the smuggling of persons and the G1 cases.
Did he also not have a failure to register as a sex offender?
Yes, Judge. In Louisiana, and I'm not quite sure if it's the same in Texas, but in Louisiana, he had another one where if you are a sex offender and you drive, you have to let their DMV system know that you are a sex offender when you're registering your vehicle. He failed to do that as well. I don't know if he was given any kind of penitentiary time for that offense, but it looks like he does have one one trip. So that would make these cases all enhanced to the next degree above it. And then the facts of the case, Judge, were somewhat troubling. There was a weapon found in the vehicle. A machete was.
Yeah, I thought it was a machete because I think we did the judge's pretrial and I kind of noted there was a machete present, but apparently he did hand that over to the officers. I mean, he didn't use it.
No, he didn't, Judge. But I think the concern.
But he had a number of people in that car, right?
Yes, Judge. 4 Honduran nationals, and all of them basically stated that they had been at a hotel with the defendant. The alleged statements are that they were smoking methamphetamine the day prior to with the defendant. He also did give an alleged statement too spontaneously there at the scene that he had smoked methamphetamine. And then he also gave statements stating that the drugs located inside the backpack were his. So he did cooperate. I would definitely work with Todd, with Mr. Dunham, so that we can hopefully get a plea agreement set. But of course, he has his right to trial. But I also want to make sure that we have the lab reports in too, Judge. But hopefully those should be coming very soon.
Your Honor.
Yeah, wait a minute. I remember this was a late night, like around midnight or something out around Anthony or somewhere.
Yes, Judge. Anthony PD is the one that makes the stop. It was a traffic stop, and it was going to be, let me make sure I get the time right. It was late at night, and it was for no taillights. And you can see in the video, the last time we were here, Judge, with other defense counsel, I know that I had requested all the videos to be uploaded. Since that time, it looks like all the videos were uploaded. It's 3 or 4 different dash cams. And then there's also, I believe, 3 or 4 different viewpoints of the drugs being tested or field tested. So there's 4 dash cam videos and then 3 looks like body cam videos that were all uploaded on June the 16th.
Do you have any idea the age and sex of the was it Guatemalan or Honduran nationals?
Honduran nationals, Judge. Yes, sir. Let's see. It looks like the first one, there was another female in the vehicle that looks like she was in the front passenger seat. She was let go. She was determined not to have been smuggled. I think she said that she didn't know anything about it, that she was just there with the defendant. But the other people involved, the first one is female, Azalea Grisel Coral.
I don't need their names, but I was kind of interested about their approximate age because of the other sexual case in the past.
She was her date of birth is 1998, so we're talking about maybe 21 years old.
Okay.
The other one was a male. He is 22. The third person is also female. Looks like she's 24. And then the other one is another female, and it looks like she is 23 or 24. So they were all adults, Judge.
Okay. Okay, Mr. Dunham, you wanted to add something else now?
Well, yes, just as to the facts, I mean, of course, this is not the place to time to discuss or debate the facts, but there are, certainly some issues from the defense standpoint as to where the drugs were found in a purse, in a backpack that CPB was taking with them when they were bringing the alleged aliens into their custody. Whose backpack it really was, whether my client's statement that was his backpack, whether that's should be suppressed, whether he made that statement. There's a lot of issues with this, and just proving the smuggling issue itself and meeting all the elements of that. Allegedly, he was with them for 14 days, and I don't know if they'll be in custody and available to testify to that or not, these people. But there were multiple people in the vehicle with one backpack that had drugs, and then there was money. So there are certainly some issues to consider from both the defense standpoint as well.
All right. Well, all right. Obviously, you want a PR bond. Mr. Cuellar is certainly opposed to that. Yeah, under these facts and circumstances and the defendant's criminal history, there's no, would not give a PR bond. And to be honest with you, I do think there is some danger to the community, and I think there is, there's some questions about defendant's ability to follow rules and whether he would show up or not.
Your Honor, then we would request, if acceptable, a lower bond amount split with PR so that he would be reporting in the PR bond, and this court would have a little more jurisdiction and control over his whereabouts.
Well, I'm going to deny that. The bond will remain where it's at. All right. Thank you, though, very much.
Thank you, Your Honor.
Thank you, Judge. May I be excused, Your Honor?
Yes, you may.
May I be excused, Judge?
Yes, you may.
Hey, Todd, I'll reach out to you, okay? So we can talk about it.
All right, sounds good.
I know the recommendation at the last rec was 15, I believe.
Yes, Judge. I'd like to keep the rec at that time, or at that amount for the time being, only because.
Okay, well, let me catch something real quick, but thank you. Okay, I believe the next one is Mr. Nieto or Miranda, whichever it is, I'm not certain.
Miranda.
All right. I believe this is cause 2021-0D01541, State of Texas versus Andreas Mirando Nieto, and is that, which name is actually your last name? Is it Nieto or is it Miranda?
Miranda Nieto.
Miranda? Okay, very good. And Ms. Pages, you're his attorney on this case. This is a straight up bond reduction case, I believe. What is his bond presently set at?
Your Honor, it's currently set at $5,000 cash surety.
5,000 cash surety, which is not an extremely high bond, but he has been in jail 65 days, which would indicate that he is not able to make even that.
Right, Judge, I am respectfully requesting a PR bond for him. And if I may just give you a couple of facts to help you in.
All right.
So Mr. Miranda Nieto, Judge, is 22 years old, and he does have family in San Marcos, Texas. When I spoke with him, he indicated that he came to El Paso for a music performance or some sort of event that he was going to take part in. He does have an apartment here in El Paso, and if given a PR bond, Judge, he would be living here in El Paso, Texas, or remain here in his apartment. He does primarily make money doing that, performing, as well as on occasion, he does do some construction and remodeling type of jobs. It's my understanding that he is no longer with the complainant, Judge, and I don't know if the state has had any communication with her. He's indicated that perhaps she's gone back to either North Carolina or South Carolina, where she's from. He also indicated, Judge, that he did self-report that he does suffer from anxiety, Your Honor, and he has been in custody quite some time. He's unable to afford this bond or posting any portion of it. And so I am requesting a PR bond, Judge, where he can report and the court can have him reporting and doing anything else that is required of him while this case is pending.
All right. Very good. Thank you, Ms. Pages. Ms. Ritchie, I obviously don't have any facts on the case. So if you would give me what the allegations are.
Yes, Your Honor. There was a verbal argument. I believe it was at a friend's apartment. She locked herself in the bathroom to prevent the situation from escalating.
When did this occur and what?
Oh, I'm sorry, Judge. On May 10th of this year.
May 10th.
At around 7 p.m. on Vrain, VRAIN, an apartment complex there.
Oh, that's downtown here. Brain. Okay. Okay, and so there was a verbal argument, and then what happened? You said she tried to lock herself where?
In the bathroom to prevent the escalation of the argument. At some point, out of frustration, she broke a glass candle, and cut herself with it. The defendant forced his way into the bathroom. She ended up walking over to one of the bedrooms where there was a mattress, and that is when he kicked her on the thigh several times, and then grabbed her by the neck, choking her, causing her to lose her breath. She got up to leave, and he pushed her out of the door, walking her out of the home where her belongings were. And so the officers showed up. They found out that he was still in the apartment hiding, and he also gave a false name and then resisted arrest.
Okay. What kind of criminal history does the defendant have?
It's not significant, Judge. I do believe that he had something an AFV out of Austin. I don't know who the complaining witness was. And let me see if there's a disposition here. There's no disposition available, but that was back in January of this year. So it might still be pending.
All right.
One other AFE judge, I'm sorry, out of Austin as well. There's no disposition here, but that was back in 2020.
So he's had 3 AFVs in about just a little over a year.
Yes, sir.
But we don't know, probably not the same complainant. I don't know. Do you know if the same complainants are alleged in those cases, Ms. Pages? You know anything about all of that?
I believe on one of them, Judge, it might be the same complainant, but I'm not exactly sure. A lot of this is taking place because he doesn't want to be in a relationship with this female.
All right. Now, what was it? Something you said, I didn't get it exactly. Something about she got cut or she cut herself. What was that?
Yes, Judge, I think that there is a tendency for self-harm with this complaining witness.
With a what? A candle?
The glass from a candle.
The what?
You know how glasses come in, candles come in glass?
Oh,
I
yeah.
think she broke the candle and used a piece of the glass.
And have you all had an opportunity, anybody in your office or yourself, to speak to the complainant?
We have tried reaching out through the numbers that we have available. We've not been successful. We are currently waiting for the Better Locate to return any new number or address. So at this time, we've not had any contact.
All right. How many opportunities, how many times have you tried to reach out to locate her?
Sorry, Your Honor?
How many times have you tried to reach out and locate her?
I believe it's the one time that we've made an actual phone call, and the other time we're waiting for the Better Locate to give us more numbers.
Ms. Pages, has your office tried to contact her for a non-pros or anything?
No, Judge, I don't have any phone numbers or anything for her or an actual address.
Okay. Well, I'm a little apprehensive because of the number of very recent assaults, but I'm also concerned too that they can't locate the complainant, that, you know, I don't, and like you said, there may be some problems between the two of them, and I don't know what that's all about. I want to give them a little more time, but not a lot more time before I take some action on the case. I'd like to give them until about next Wednesday. I'd like to have another hearing just on Wednesday. Or maybe let's make it Tuesday, because I usually do criminal cases on Tuesday. But they would only be with obviously with you and Miss Ritchie, and I'll make my final decision. I'll take it under advisement until then.
Okay, thank you, Your Honor.
Thank you.
Mr. Miranda, I will contact you, okay?
Okay.
Thank you.
All right. Now we have Mr. Para.
Yes, Your Honor.
And let's say, what are we doing? Okay, is this also one of, this is your case, Mr. Lopez, I believe?
Yes, Your Honor.
And I think we talked about it earlier in the week.
Yes, sir.
And we are trying to.
I met with my client, Your Honor.
Yes.
I think what we were discussing is that he has not done very well on probation. And what was being discussed is possible modification, extension, and sending him to either SafeP or BHRTC.
Have you got a chance to talk to him about those issues yet?
Yes, I did, Your Honor. And in fact, we came up with an alternative. Hopefully, if maybe I can have a breakout with the ADA. Or if we want to do it, that's fine. We're looking at a possible jail rec on this state jail felony.
Okay, so you're thinking about maybe resolving it by a revo in a certain amount of time.
Yes, sir.
Okay, and so you want to, I think they've put out a possible, I think the probation department's position is they want to kind of go with an inpatient treatment, but you all are coming back with, after talking to your client, you've talked to him about inpatient treatment.
No, what was discussed last time was either BHRTC or safety and an extension.
Right, those are inpatient treatments. But you are thinking about maybe a jail commitment of some form.
Yes, Your Honor. I heard a counsel earlier express his concerns about the time limitations and how things move.
Yeah, it can take 30 to 60 days to get you transferred from the jail to either BHRTC or SafeP.
And then,
and then of course you're there for periods of, you know, 3 to 6 months on BHRTC. SafeP is even a little longer. Let's see, Ms. Ortiz, how long is that? Is that 6 months about, or 9 months?
For which one, Your Honor?
SafeP.
I believe it, yes, it's a little bit longer than that.
So I
it's
think
about 6 months.
9 months. Yeah, and then you have maybe a halfway house after you come out of safety. And so you're also, so you're, after talking to your client about those options, you're wanting to come back with a counter option of a certain amount of jail time?
Yes, Your Honor. And the reason for that, it's not a drug case or things of that nature. It's an unauthorized use of a motor vehicle. It's state jail. He's been in custody for approximately 3 months.
Okay, why don't we do this? Why don't we reset this for a hearing on Tuesday now? Because you've had a chance to talk to your client. And like I said, I never like to send people to BHRTC or SafeP if they're not on board. And like I had 2 of them earlier, and that's what they really wanted. But theirs was mainly a drug issues. Your client is saying that his is something else. And so he's indicated to you to negotiate for some, I assume, for the least amount of time he can get.
Yes, Your Honor. He believes that once he is released, he will continue treatment on his own with family help. Not drug use. He has other issues, health-related issues.
Right, and I think we're aware of those.
He believes he can get the help outside.
All right, well, let's do that. Okay, Mr. Pata? Yeah, what we're gonna do here is your attorney and the state's attorney are gonna meet with me on Tuesday, and we're gonna discuss this option of a jail commitment of a certain number. And then if they can come up with an agreement as to what amount of time, then Mr. Lopez will get, your attorney will get back with you and see if that's agreeable, and then we'll see where we're at, okay?
Okay, Your Honor, thank you.
Okay, thank you. You take care.
Thank you. Do I reach out to you, Ms. Ritchie, or you reach out to me?
Well, what we'll do is we'll go on a Zoom conference on Tuesday, and at that point, well, you two can talk tomorrow or Monday about, and then if you come up with the idea of whatever you think is good, and then I can, we can resolve it, on Tuesday, and then we can come back next Thursday if it's a commitment and finish it off.
Thank you, Your Honor.
All right.
Sounds like an excellent idea. Thank you, sir.
Thank you. Take care. Okay. Let's see, next I believe is Mr. Portillo. And Ms. Pages, we have kept you very busy today.
I know.
Okay, and this one is another bond reduction.
Yes, Judge.
But now this one I did get the facts once before, because we did have the judge's pretrial conference back in, I think, June of this year, and I got his criminal history. So we have all of that already taken care of, but we've never done a bond reduction hearing yet. And let me see if I can go over some of that. If I've got anything wrong, let me know. Well, first of all, though, what I don't know is, let's see, I may not have the amount of bond. How much bond is he on?
Your Honor, it's $250,000.
Okay, that's combined.
Yes, Judge.
Okay.
And I am asking for a $50,000 cash surety and a PR.
Okay, so it's 250 cash surety, and he's been in jail like 100 days. Jail. That's, yeah, 250,000 is a very high bond. And so defendant requesting 50,000 cash surety. And then the remainder, I guess, is PR.
Yes, Judge.
Okay, let's go back over, let's see the facts as they were alleged before.
I apologize, Your Honor. I'm showing 290,000 cash for surety.
Oh, okay, you show 290? Okay, it's a little more. All right,
Actually worse.
it's a little worse. Okay. So then it would be like 50,000 cash surety and so 240,000 PR or something. Okay, let's see. We have, the initial rec on this case was 7 years prison. Apparently they could enhance him because he has had some prior convictions. Looks like one of them for ag robbery and burglary of habitation back in about 2017. He's also done some jail time on some burglaries of vehicles, and some evadings, things like that. What, Ms. Ritchie, just briefly, make sure I've got the facts right. It was about April 6th of this year, about 9:20 in the morning on Copia. Defendant was a suspect evading in a vehicle, and they're trying to, this is the one where they were trying to, the police officers were trying to get the defendant pinned in between a vehicle that was in line. It was some kind of a fast food place or something. Is that right?
They were pinning him in, Judge, but I don't recall the fast food place.
Oh, okay. Well, it was somewhere. Okay. I got the impression that it was a fast food restaurant nearby. And so then apparently he runs into the patrol vehicle.
Yes, sir.
And then I don't believe, were the officers injured? I don't believe they were.
I don't believe so, Judge.
They discontinued pursuit and he was seen running on foot, and they catch up with him on foot. They say he's resisting, so they taser him. They find some drugs like THC wax, heroin, marijuana, something like that. Is there anything else that was, because it's an assault against a public servant, it's evading in a vehicle and evading on foot.
And one of them, Judge, I believe is a possession less than a gram.
Right.
And,
Oh, that's right. Possession under 1 gram.
Yes.
Which must be maybe either the heroin or the THC wax or something. Okay. And the criminal history. Did I have it right? Is it 1 prior pen trip?
Yes, Judge, it looks like they were all, he was revoked on a couple of things, but it looks like 1 trip.
All right. Was this the case where the officers outside of the car at some point were he hit them or almost hit them or something? Go over that with me. I don't know. What's the allegation?
Okay, so I think that he began to flee. They pinned him in an attempt to stop him, and that is when he began to ram his car into the vehicles. Some of these were not marked units. They were civilian type vehicles. So I don't know if he knew that they were cops at the time or what the deal was.
Right, Judge. And so that is the huge issue that I have with this case, is that none of these vehicles were marked. There were no lights or sirens to have given him any notice that these were in fact law enforcement officers. And so the fact that he's charged with an aggravated assault with the public servant with absolutely no injuries on these officers is just hard for me to believe. But none of these units were marked, Judge, no lights or sirens. Mr. Portillo is, Judge, he's 26 years old. He has 2 children, both of them.
Let me get some of this information now. You said he has two sons, I believe, 9 and 5.
Right. He was working as a machine operator at the El Paso paper box. And if this court does reduce his bond, Judge, he will be able to obtain employment full-time as a machine operator again there at the El Paso paper box. He is from El Paso, Judge. He does have a GED. He has family here. He would be living with his sister, Abigail Portillo, and his mother, Leonarda Dominguez. He also has a girlfriend. He has received mental health services in the past, Judge, for bipolar and depression through EHN. And like I said, Judge, none of these units were marked. I have requested any type of video. I don't believe that there's any or any has been uploaded in the portal to indicate that any of these units were marked and that there were lights and sirens.
All right,
We are requesting a reduction in his bond.
all right.
And Judge, so my problem with this is that if they aren't marked, they could have been civilians, which to me is more offensive than the fact that he could have been hurting, you know, people in our community, not just officers. The other issue is,
How fast was he going when he was hitting these? Was he like, kind of like, if they're pinning him in, it sounds like they're trying to get in between both bumpers. So is it like he's hitting their bumpers, or what's he doing?
It's at a stoplight, or it's at a stop, Judge. So he's not even really driving, and he's not charged with, you know, I understand Ms. Ritchie's concern, obviously, but he's charged with what he's charged with, aggravated assault with public servant.
Has your video shown us the extent of damage to these vehicles, or have you seen it, either of you?
there are photos, Judge. I mean, they're not like, you know, super drastic damages. There's scrapes, there's some bumper damage. Let me look back at some of these.
And I mean, it's not, I think I had another case, and I might have been getting it confused with that, where I think the police officer was outside the car and they almost pinned him to the bumper, which that's a lot different than if they're in the vehicle or they're out of the vehicle.
Right.
You could cripple a person, at least if you caught him between the bumpers, but that's
Right.
not this case. That's a different case.
I know that the airbags were not deployed. I think the car that was messed up the most was the Chevy Cruze, which was one of the officer's vehicles. It looks like the bumper was destroyed all the way up to the front, like the tire is exposed. It's not protected by the bumper anymore. And then my other issue is that he is a Crip gang member. So that does cause a Crip gang member, Judge?
No, Judge, he is not a confirmed gang member, and he's indicated to me that he's not a confirmed gang member. That was in the past, and that's no longer his current life. He does have 2 small children, and he was working full time. So he's not the person that he was before.
Okay. All right. In regards to the bond, 50,000 cash surety and then some PR. Are you opposed to that, Ms. Ritchie?
Yes, sir, I am. I do think that that's pretty low considering his priors and tendency to flee and resist authority, Judge.
You all have those pictures. I do not. I don't know what they look like. If you want, are you all going to be in the courthouse tomorrow, Ms. Pages, Ms. Ritchie?
I will be, Judge.
Okay, Ms. Pages, will you be here?
No, Judge, but if you need for me to be there, I will be there.
All right. Well, if we could you all meet with me tomorrow morning then on this and bring me, like, so I can see what this damage looks like, you know, because I want to see if he's really hitting the vehicles really hard or not. I mean, I kind of want to do that based on the
Judge, and I can tell you, based on these photos, that it's not nearly anywhere close to that at all.
It's
All right.
not super crazy, Judge.
It's not.
All right. Well, I kind of want to see it. So, and then I'll set the bond tomorrow when you come up. We can do it at 10 o'clock.
Okay, Judge.
That's fine. Actually, Judge, tomorrow morning, I do have an appointment. I forgot. I do have a medical appointment tomorrow morning.
Okay. What time is convenient for you tomorrow?
Is 8 o'clock too early?
Eeks. Yes, I won't be here then.
Okay. I have an appointment at 9:15. It shouldn't take that long.
You tell me when it's convenient for you.
Okay, I should be out of there by 11. So how about 10:30 to 10:45? Is that okay?
Did you say, oh, you said you should be out of your appointment by 11?
No, I should be out by 10.
Oh, 10. Oh,
Mhm.
all right. Well, then
About 10:30, 10:45?
10:30 is fine.
Okay,
We'll see you both tomorrow at 10:30.
okay, sounds
That's
good.
fine. Thank you very much.
Thank you, Judge.
All right. All right. Next is Mr. Franco. Do we want to continue on with hearings? I think it's the last hearing of the day. We've actually already thought about the bond hearing here.
Yes, Judge. This is Andres Caballero for Mr. Franco. Last time you had asked me and Ms. Clausen to get together and discuss
Yes.
specific conditions.
Yes.
I gave Ms. Clausen the number to the provider of the GPS device, and she said she wanted to call them and see what the capabilities are of the device, and then we would get together. However, recently, Ms. Clausen is out of town. I checked in with her yesterday. She's out of town because a family member, the loss of a family member.
Oh.
So yes, we didn't have a chance to discuss specifics on the matter. I don't know when she's returning. I just got that she was out of town.
Okay, Ms. Ritchie, do you have any idea when Ms. Clausen was returning?
I believe she's supposed to be back on Monday or Tuesday.
All right. Why don't we wait till she gets back? Because I mean, she's worked on this case personally, and and I think the three of us worked on it pretty closely together. I think we were pretty close on the idea of what to do. We just had a couple little details that we needed to work out. And
yes, sir.
I don't think we absolutely have to do it, where the defendant is present. I just want to inform him that, he needs to very carefully follow. If we set the terms and conditions on this PR bond, they will be explained, or the portions that are PR. There'll be cash surety, a heavy cash surety issue involved. There'll also be some PR conditions involved that I think your family has been in discussion with your attorney and with the state's attorney and with myself. So we've had several hearings on this without your presence. I think the only thing that we wanted your presence for was to make sure that you understood you had to very carefully follow the terms and conditions of this bond, if I said it. All right?
Yes, Your Honor.
Because your family would be, putting up some substantial, bond money and assets that it would be very bad for them if you didn't.
Yes, sir. I just have one question, Your Honor, in regards to employment. I've been in the restaurant industry for most of my adult life. Would there be any issues or conditions as far as working in the restaurant industry?
Yes, I think we discussed that, and I think my position was I would rather no. I did not, not to start the bond. I think the idea was that you were going to help take care of your mother, and
yes,
that was about it. Okay.
Yes, sir. Yes, sir.
So I really don't want employment outside. Isn't that what we said, Mr. Caballero?
Yes, Your Honor. You said it, initially for the transition, no employment outside. He can do catering, but if he must stay at the home, he can make meals and someone else can deliver them if he can find someone to do that. But for the time being, not to, no employment outside of the house.
Yeah, we want you pretty close to that house.
Yes, sir.
So that was a major condition. So I will talk with your attorney and the state's attorney just as soon as Ms. Clausen gets back and as soon as we can arrange it. I assume it'll be early next week.
Okay, thank you, Your Honor.
All right. Thank you, Mr. Caballero.
Thank you, Judge. May I be excused?
Yes, you may. And so I think that concludes our hearings for today. Thank you all from the annex.